Can a set of instructions written centuries ago by people who are now dead compel us to act or not act in particular ways? One of the concerns with respect to constitutional interpretation says that while following the original instructions is important for stability and coordination, it is not the only thing that's important. The well-being of people living today is also important. This suggests that it's foolish to bind ourselves too tightly to instructions given to us by people who lived in significantly different times and faced significantly different problems. Imagine that we're living in England. Also imagine that when King Henry VIII died in 1547, they read his will and they discovered that he said the following, quote, "I name no heir to my throne. I am to remain England's king until the end of time. Towards that end, instead of naming an heir, I'm leaving you these instructions on how to run the country in my absence. As loyal subjects, you are duty bound to obey these instructions as you would obey your king." End quote. Now granted, if they seem to be pretty good instructions, then perhaps we should follow them. But our obligation to follow the instructions isn't because they come from King Henry. It's because they seem to be pretty good instructions. However, since the instructions were written by mere mortals, it's likely to contain a few flaws. And since our reason for following the instructions is that they seem to be good instructions for us to follow, then where there are different potential interpretations to those instructions, one of the ways in which we should select an interpretation is according to which provides us with the best set of instructions to follow. This is the main point behind a living constitution. We're given a set of instructions, but we have lives to live, and those instructions were written for a different time and different circumstances. So we have a choice. We can bind ourselves to the instructions of people long dead who had no idea what problems we had, or we can interpret the instructions in a way that conforms to our current situation. When they wrote the First Amendment, they had no idea that we would have broadcast television and the internet. When they wrote the Second Amendment, they had no idea that we would have automatic rifles and multi-shot pistols we could hide in a pocket. When they wrote the Fourth Amendment, the part that protects us from unreasonable searches and seizures, they had no idea that technology would allow systems of remote eavesdropping and the collection of vast amounts of personal data stored and correlated in vast computer networks. When we apply the old rules to these new situations, the only reasonable and rational thing to do is to interpret them in a way that provides us with the best possible set of rules. Let's take the Second Amendment as an example. When the Second Amendment was written, guns were single-shot weapons. A proficient soldier required 15 seconds to reload and fire. The same is true of pistols. There's no possibility of mass shootings, and the authors of the Second Amendment could not have even imagined, well, how will this amendment work in 200 years with weapons that can fire hundreds of rounds in a minute? It's also relevant to note that a majority ruling that a type of law is unconstitutional has the effect of rendering state and local governments impotent when it comes to creating laws that apply to the new weapons. In the case of New York State Rifle and Pistol Association versus Brune, the Supreme Court took power away from state and local government. Local voters cannot decide what rules are best given the changes that we have seen in firearm technology. They must apply a rule written 250 years ago when firearm technology was significantly different. But can a judge consider the consequences of applying an old rule to new situations in interpreting the old rule? Originalism says no, apply the rule as written. Living constitutionalism says, yes, the rule changes as technology and culture changes. So what argument can somebody who accepts the doctrine of a living constitution give for that thesis? One line of reasoning rests on the premise that if you can cause something good to happen or prevent something bad from happening, then it's a good reason to do something. It may not be the only reason, but it has a place on the scale and may, in some cases, tip the balance one way when it might have otherwise gone the other way. In the Supreme Court case of McCulloch v. Maryland, 1819, Chief Justice Marshall wrote, quote, "We must never forget that it is a constitution we are expounding, a constitution intended to endure for ages to come and consequently to be adapted to the various crises of human affairs." End quote. Thomas Jefferson, the third president of the United States, originally believed that the Constitution did not give the government authority to purchase territory. Yet when France offered the Louisiana Territory to the United States, he couldn't resist the opportunity. To defend his actions, Jefferson wrote, quote, "A strict observance of the written law is doubtless one of the high duties of a good citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger are of higher obligation. To lose our country by a scrupulous adherence to the written law would be to lose the law itself, with life, liberty, property, and all those who are enjoying them with us, thus absurdly sacrificing the ends to the means." End quote. Okay, now, an originalist objection would be that adopting the living Constitution view is too haphazard, too chaotic, as different judges disagree on what will bring good consequences. We need a government run according to the rule of law, not to the whim of a half-dozen appointed officials. Against this specific argument, the living constitutionalist can say that it's self-defeating. The originalist that uses this argument is saying that it's wrong to consider the consequences when determining what principles to apply to interpreting the Constitution, because it would produce bad consequences. The originalist is going to need a different kind of argument. Another defense that a living constitutionalist theory can offer is that originalism can do no better. Deciding on the original public meaning of text is as problematic as deciding on what will serve the public interest in our current situation. Religious scholars have had thousands of years to decide on the meaning of biblical passages, and disagreement seems to grow over time, not shrink. Another originalist objection is that it's up to the legislature to determine whether it is worthwhile to pursue these good consequences or avoid bad consequences. However, when we're talking about the Supreme Court applying an old rule to declare a law unconstitutional, the Supreme Court is denying the legislature the power to determine the merits of applying that old rule to a new situation. At least in these types of cases, it is inconsistent for an originalist to say that these types of decisions belong to the legislature when, at the same time, they say that the Constitution prohibits legislatures from making these types of decisions. If it is true that these decisions belong in the courts, then the question of the effects of such a decision also belongs in the courts. A third originalist objection would be to point out that the Constitution has an amendment process. If one thinks that new rules are needed for new situations, then one should pass an amendment. The living Constitution response to this may be to argue that the amendment process doesn't work. For all practical purposes, it's impossible to update the Constitution in any significant way. A sufficiently small and well-funded minority can prevent any change for the public good. So, we're forced to live with the old rules being applied to new situations to our detriment, unless another way of making positive change can be found. Against all of this, the originalist objection that there are problems with having unelected judges amend the Constitution as they see fit remains. The objection to a living Constitution theory is that we are taking a huge risk granting judges that type of power, and the best option is to bind judges to the original public meaning of the Constitution. Against this debate, the moral fact theory claims to offer a route between these two extremes, combining fidelity to the Constitution as written with flexibility in applying its rules to new and changing circumstances.